The Electoral Court has temporarily put the Independent Patriots for Change, IPC's legal challenge on hold in their bid to nullify the 2024 National Assembly election results. Judge Hannelie Prinsloo ruled that the case is urgent and should be resolved between March 21st. However, proceedings are paused for now, waiting the Supreme Court's decision on the presidential election challenge, which is set for hearing on February 10th. That ruling is expected to shape the direction of the National Assembly case. To help us break this down, we are joined in the studio by the lawyer Henry Shimutwikeni from Henry Shimutwikeni Corporation. Welcome to Daily Roundup.
Good evening. Thank you for having me.
Yes, just to get into it, what does the postponement of IPC's National Assembly election challenge mean legally?
Look, I think in terms of meaning it's one thing, but in terms of where it comes from perhaps is more important. It's important to understand that currently we have challenges to the elections in two courts, which is in the Supreme Court as well as in the High Court, which serves as the Electoral Court for these purposes. Now in the Supreme Court is where we're having the presidential challenges heard. In terms of the Electoral Act, if you want to challenge the outcome of a presidential election, you must do that in the Supreme Court. And if you want to challenge it if you want to challenge the National Assembly elections, you then do that in the Electoral Court, which has its seat in the, which is a division of the High Court. Now, what we're seeing is that the facts and the issues which are raised in the Supreme Court and the facts and the issues which are raised in the High Court are basically almost the same. Primarily it has to do with the administrative glitches or the administrative hiccups that the ECN did, and the other leg on which they are relying is the aspect of the President's proclamation, which extended the voting dates to the 29th and the 30th. But the only difference is that in the one matter in the Electoral Court, they're asking here at the bottom for the National Assembly elections to be set aside, whereas in the other court, in the Supreme Court, they're asking for the presidential elections to be set aside. But if it is hypothetically the event that the Electoral Court was to make a particular decision and a particular party wasn't happy with that decision, the court they would appeal to is the Supreme Court. So one can imagine that the rationale and thinking besides in the minds of the adjudicators was to say that the Supreme Court is the superior court. In any event, if we make a particular decision, let's say the High Court was, the Electoral Court was to say, no, the President was correct in their proclamation, and then a few days later the Supreme Court makes a decision and says, no, but the President was wrong. Then number one, with no offense to the court, but they would sit with egg in their faces. And in any event, from a practical perspective, it would be a decision which would be overturned by the Supreme Court to align it with their own decision.
Of course.
Yes.
And how common is it for an Electoral Court case to be put on hold pending a Supreme Court ruling?
Look, I think our circumstances are quite different. When you ask common, if we look historically at our challenges, the most recent challenge we had was with the 2014 legislation, because this act is Electoral Act of 2014. The most recent one was the presidential challenge, which was brought by Dr. Itula at the time in the absence of the IPC. So at the time he didn't have a party. He just challenged it independently as a presidential candidate. So he only went directly to the Supreme Court. So it's new territory for us in terms of this happening. And I think it's something which after this particular case perhaps is going to require some kind of legislative reform. It's going to need some legislative reform. Of course.
And what legal precedents, if any, could influence the Supreme Court's decision on the presidential election challenge?
Look, by precedents, I'm going to assume that you mean decisions perhaps that the court will consider.
Yes.
Look, I think when it comes to electoral matters, particularly when it comes to national elections, one normally looks beyond your own jurisdiction and primarily Commonwealth countries. I think obviously when it comes to aspects of materiality and one looks at various elections, but I think if one looks at Kenya in 2017, there was I think the gentleman's name was Raila Odinga against Uhuru Kenyatta. And yes, and then the court declared initially the electoral body of that country announced Uhuru Kenyatta as the winner, and then Raila Odinga took it to the relevant forum, the court, to adjudicate it, and the court then set it aside and ordered a fresh election. But then Raila Odinga later on never participated. So the facts are over, and Kenyatta was declared the winner because he decided not to participate. But then I think when it comes to electoral matters, you extract certain principles from jurisdictions, but the facts and legislations which govern principles, which govern elections in most countries are always different. For example, the aspect of the declaration of an extra day, I can't recall, just from the back of my mind, I can't think of one possible case from another jurisdiction which has a similar fact. The aspect of materiality and, that is quite common. That is quite common. But the aspect of the challenge to a proclamation to extend the days by 2, I can't from the back of my head think of one particular case, but that's the nature of law. The law responds to facts.
Of course.
The law responds to facts.
Of course.
Yes.
And just, Henry, Judge Prinsloo ruled that the case must be resolved on March 21st, or before March 21st. Is this the timeline? Is the timeline realistic in your own opinion, given the legal complexities involved?
Look, electoral matters such as these are urgent applications in their nature. Just last week, for example, an unrelated matter, I was at court at 10 in the evening to set aside a particular decision, and the court woke up and made a particular decision at the time. So there are very strict timelines set by the Electoral Act in terms of which they should resolve this matter. And the rationale, obviously, of the 21st of March is because the term of the current legislatures, and by extension the government, is going to expire by that date. So I do believe it is something that the court is able to achieve.
Yeah, and if IPC fails to pay the security of 450,000 by February 11th, what legal consequences will they face? Look,
Section 169, 4 to 8 of the Electoral Act makes it quite clear to say that before an application is heard, a person must pay security, the security which will be determined by the court. The court has made the determination in terms of security amount. So before that particular matter is heard on that substantive day, IPC should have paid that particular security. In the absence thereof, the court is simply not going to hear the matter.
Of course.
Because that is what the law dictates.
Yeah.
Yes.
And the judge also dismissed arguments that the delay will disrupt SWAPO's governance plans. How does the law balance electoral challenges with governance stability?
Yes, I think with regards, I think SWAPO's intervention in the matter is quite odd, because this matter is a matter which is brought against the state entities and then the ECN itself, who is the custodian of the election.
Of course.
Because hypothetically, imagine if it was that every other party that participated in the election decided, and there were 22, I believe, decided to advance arguments. I think it would be a very cumbersome process. So I think the SWAPO party's arguments are noted, but one ordinarily would not expect that a party would be at the forefront in terms of the adjudication of an electoral matter which was in the custody of the electoral body. There's 22 other parties. Imagine if the 22 other parties decided to file affidavits too, to say, oh, I support, I don't support, I want to support arguments. It's going to turn into, for lack of a better word, a little bit of a chaotic situation. Yeah. Yes.
And based on your expertise, what key legal arguments might IPC present in their challenge to nullify the National Assembly election result?
Look, I think the biggest thing one has to convince the court is materiality, the materiality of the particular hiccup or whatever it is that they're crying about. And remember that there's two things here. There's the aspect in terms of the handling of the elections, and then there's the aspect in terms of the declaration. In terms of the handling, which the intention is to ask that the election be set aside, that would require one to prove materiality. But look, here's what I always say. This particular election which we had now had a voter turnout which was one of the highest in the past two elections. We had a voter turnout of, I think, 70-something. Before that, I think during the first time when His Excellency, the late Dr. Hage Geingob was elected, I think even then it was at 60-something. Yeah. So this voter turnout was extremely high. So I do think they have a very high hurdle to jump over in terms of convincing the court that the mistakes were material enough but I don't want to preempt what the court is going to decide. That's just my view. I think it's a very high hurdle that they have to try to climb. But in terms of the other one, my humble view is that perhaps the chances are higher in terms of the declaration. But then again, I think there's only about, I don't think there's more than 20,000 votes from that day. I think it was 9,000 votes or so. So again, materiality does the court order that they exclude those particular votes? Is it significant enough from the 1 point something votes that were cast to set aside the entire election?
Of course. And lastly, just as you also just in the question that I'm going to ask now include your general overview about the whole court case. Maybe how might the Supreme Court's ruling on the presidential challenge impact the National Assembly case?
Look, I think that links to what we just discussed a bit earlier, to say that the highest court in this country is the Supreme Court. If the Electoral Court was to make a decision, the Electoral Court, which is the lower court, and someone was unhappy with it, they would appeal to the Supreme Court. So my understanding of it is that the Electoral Court stands to be guided by the determination of the Supreme Court, because the factual allegations are in essence very much the same, if not similar to those that side. So I believe that the Electoral Court stands to be guided by the determination to be made in the Supreme Court.
Thank you so much for being on the program today.
Thank you very much for having me.
All right. Of course, that was Henry Shimutwikeni from Henry Shimutwikeni Corporation. He just gave us a brief on the court case of IPC's legal challenge. We'll be back after this short break. After this short break.